This is not a individual negative statement. It's only a positive statement.
BHU had been set up earlier. It's indicated that an undertaking was given to the Hindu leaders at that time.
The object and purpose was to conserve the distinct language, script, and culture of the Muslims. That's clear from the Constitution.
No, there I have a...
In this video, you will watch arguments in Honorable Supreme Court of India with regarding to the case of Aligarh Muslim University minority status. The judges asked some questions in relation of establishment of AMU and the BHU Banaras Hindu University, and what were the response from the advocates on those questions. You will watch.
That when they set up AMU, they had a precedent, namely of BHU.
Correct.
BHU had been set up earlier. It's indicated that an undertaking was given to the Hindu leaders at that time, that when AMU was set up, it will be set up on the same pattern as
Pattern and lines as yes.
And therefore, AMU itself was set up on the same pattern as BHU. That I think we also find at internal page 42, middle of page 42.
Yes.
Meanwhile, the Hindu leaders, who had in their turn approached the government of India with a scheme for establishment of a Hindu university at Banaras, guided by that practical spirit, which is one of their characteristics, accepted the conditions laid by the Secretary of State, etc. An undertaking was at that time given by the government to the Hindu leaders that the university to be granted to the Muslim community
would also
be on the lines of the Hindu university.
Therefore, my lords, two things really come out. One, consciously it was decided that even at the inception, it was to be taken to be an institution of national character, pre-constitution, on the lines of BHU.
But equally, this was an institution which was granted to the Muslim community.
That's
right. Also ignore that.
No, but one thing, my lords, as what Mr. Dwivedi was pointing out, maybe for the benefit of the community, my lords, in terms of students, etc. But please see section 8. It said that it is open to all. That's very important, my lords. Teaching of theology was for those who wanted to study it. And post-constitution also, in terms of 28.3, any teaching was subject to consent. That's very important, my lords. In fact, on that point, I wanted to just, for a minute, my lords, get out of this and get into the meaning of the expression for institutions of their choice found in Article 30. In at least 3 decisions, my lords have said what the meaning of this expression of their choice is. It's not just choice of the manner in which you do the administration as what is sought to be projected. No. Which means an institution for the development and benefit of that minority, be it linguistic or religious, for which the institution is formed by the founders. That's how you understand the expression of their choice. Give me those 2 documents. Mention that in my supplementary submissions, what the meaning of the expression is of their choice. Just note that, my lords. Volume 2, P, my lords, P for Peter. That's my supplemental submission. 2P, page 14. I have extracted from, my lords, St. Xavier's. Given that specific extract from Xavier's, my lords. The second point, my lords, arising, coming back to the point which I was submitting.
No, but if you read the second part of 96, the case of educational institution is established by a minority to conserve their distinct language, script, and culture. This was an institute which was meant to conserve the distinct language, script, and culture of the Muslims. To that extent, it's quite clear in the enactment itself.
Not exclusively for that.
No, it allowed others to come and...
Correct.
But the object and purpose was to conserve the distinct language, script and culture of the Muslims. That's clear from the constitution.
No, there I have a caveat, my lords, to a writer to add.
From their number of places where they've used the word Muslim.
No, they do. They do. My submission in response to what is falling from my lords is this. The primary object was not that. The primary object of the institution, even according to the appellant, was to give liberal education.
To whom?
Yes, what they said to their community, but then it was an institution which was designed and made, established by, my lords, the imperial legislature to be one open to all, with liberal education. Section 8 is a clear answer to that, my lord. Section 8. That's what in my respectful submission ought to be the consideration, my lord, while looking at this. Therefore, the second point which comes out of this is this, my lords. One, institution of national character pre-constitution, even prior to the constitution, at the commencement of the constitution, while putting it bodily into the constitution, the understanding was this is an institution of national importance going beyond the communal tag. That's the second important takeaway from this point I want to say, my lords. And one more aspect. Ultimately, the proof of the pudding lies in its eating. Now, what does all this mean? What does all this translate into? By Parliament declaring by law that an institution is of national importance, what happens? Straight away, my lords, 4 or 5 features.
So what safeguarded was, it prevented the state legislatures from interfering.
Pre-constitution, correct.
It was a clear indication that the state legislatures will not interfere in these 3 issues.
It will be the imperial legislation.
It will be only the imperial legislation.
Correct.
And after the enactment of the constitution, only the central parliament.
Parliament, yes. That's right.
And the executive interfere.
That's correct.
So
That's
that
right.
they wanted to save them or give them an umbrella, ensuring that it's only the central government and which interferes or will regulate their affairs.
For the reason, that's important, my lord. Absolutely right. For the reason that they are institutions of a national character and of national importance. That's the point, my lords. That's the reason why
That's the way they distinguish them. Yes, certainly that's used. But the question which was posed by the Chief Justice also was, will branding the institution or characterizing them as an institute of national importance do away with their character as minority?
It's at two levels that I want to respond to that. It's at 2 levels. Number one, while as a proposition, it is right that it need not.
Into it.
Sorry, my lord.
We can't read it as a negative stipulation.
No, I'm saying something else. First level, yes, but at level 2,
it's a positive stipulation, not a negative stipulation.
no, the indication clearly being this. By declaring an institution to be an institution of national importance, the Parliament has decided that it shall acquire a character which goes beyond.
This is not a individual negative statement. It's only a positive statement.
No, I'm saying the meaning, therefore, constitutionally is that this now acquires a certain character where it goes beyond the position of all regular institutions, gets to the next level. And that's why I was saying how by being declared by law, so many other consequences follow. One of the main things, my lords, substantial government funding.
Guru, do we have the report of the standing committee which presented its report to the imperial legislation in this compilation?
Yes.
Just give us the page.